Good evening, Mr. Wilson.
Good evening, members of the Judiciary Committee, Representative Tong and Senator Coleman. Thank you for listening to all of us here today, and I know it's a long day. My name is Scott Wilson. I'm a resident of New London. I'm also the president of the 2A grassroots organization, Connecticut Citizens Defense League. And I'm here today to state that I oppose all three of the bills that were heard today, HB 6962, SB 650, and 6848 as well. I'm going to throw out most of my testimony, but on the what's called the Burglar Protection Act, 6962, I'm going to just say that I don't understand why there's no discussion that if somebody comes into my house and I've got firearms locked up or what I consider locked behind a locked door in my house, that there's no discussion about punishing criminals more, statutory penalties for breaking in and stealing a firearm from somebody and either going on to sell it or use it in the commission of a crime. Instead, we continually seem to go to the pool of what we like to say around here ad nauseum, law-abiding gun owners. We're the ones that are punished. We're the ones that are held accountable for the actions of a criminal, and it has nothing to do with anything on our part. Now, I'm going to just tell you that when I was a youth, I was at home, and a friend of a relative brought a gun over that he stole from his father, and he put it in my relative's hand, and my relative was fiddling around with it, and the next thing I know, I'm bleeding. I'm bleeding everywhere, all over the place, okay? And what happened was the bullet hit my shoulder, hit my neck, lodged against my spine, hit the artery in my neck, and I was in the hospital. I lost the use of my arm, and I'm still here today to tell you that I believe that people need to be able to have access to their firearms in the way that they deem fit, in spite of all that. My Second Amendment rights trump whatever self-storage laws that are trying to be imposed here, added on top of what's already existing in the state statutes. So as far as restraining order type laws that are proposed here today, I think that the bill is going to remove the due process that everybody's talking about, and I think that that there is another measure already in the statutes that's already been mentioned by Art O'Neill, and that's 2838C, and I think that as opposed to enacting new laws and toppling legislation on top of other legislation, let's look at the existing laws. I am surprised too, Representative O'Neill, that people aren't more aware of that law. And again, like any law, there's always a potential for abuse. Even this law, it's probably happened. Okay, it's probably happened. Anytime somebody can just show up at your doorstep and seize your property, there's a potential for abuse there. Still, it's better doing it that way than just having somebody say they feel a certain way. Real quick, I just want one more second here. I've waited all day. And I want to say that as far as the revocation of a pistol permit after somebody has their firearm seized, okay, imagine, did we have a long winter? We did, didn't we? And imagine going through a winter, a spring, a summer, and a fall and doing it twice, okay, 2 times, 2 consecutive years, and then throw in all the additional people that are going to lose their permits because of this law if it's enacted. Now you're going from 24 months, and now you're adding new people in, and it's just going to extend the hearing time. And right now we're trending outward anyways, even without this law. So you're going to be looking at God only knows what amount of time before you can get your guns back in the state of Connecticut.
Thank you, Mr. Wilson.
Thank you.
And I do appreciate that you've been here all day, and I thank you for your patience.
I appreciate you guys. Thank you, Representative Tong.
I do want to ask you a question, but then I want to address a couple of your comments at the beginning of your testimony with respect to burglary and criminalizing people who would break into your home and take firearms or do whatever. In fact, since I joined this legislature, we've done a lot on this issue. I'm sure you're aware that a lot of people are aware that we've done a lot on home invasion, for example. And criminalizing that kind of behavior. You mentioned firearms that are lost or that are stolen. my freshman session, we passed a bill called the Lost and Stolen Firearms Bill that I worked very closely with Representative O'Neill on.
Right.
That I will note was opposed largely by the NRA, but we were able to compromise and find a way, and I think that's helping to keep people safe every day now when lost or stolen firearms are used in the commission of crime.
Yeah, I think people should report their firearms stolen.
Thank you. I wish you were here 8 years ago. I want to ask you about the due process concern, though, and I know it's getting late, but I've heard a lot about due process, and it seems to me that, well, due process is one of those words like constitutional, you know, we sort of throw it around. They're loaded words, not always sure what they mean in a particular context. But I guess if I could summarize the concern, the due process concern with respect to the temporary restraining order ex parte process is that the person against whom the restraining order is sought is not able to be heard at the moment that a judge decides to dispossess them of their firearm. Is that correct?
Yes. Yes.
And it's this basic concern that the person ought to have as a manner of due process, the opportunity to speak out and to offer competent evidence in support of their position. Is that right?
I think people need to be able to have their side of the case heard. I mean, to sit there and think that somebody can show up at your house and serve you with a piece of paper that says you've got 24 hours, turn in all your guns, and you're compelled to do so or face additional penalties on top of that. I think that, to me, it sounds like I fell asleep and woke up and I'm in East Germany circa the Cold War era.
And I understand the argument. I also understand that in order to get the restraining order, I don't practice in this area. I did work on one order of protection case early in my career, but it's my understanding you have to carry the person seeking the order has to carry their burden to show that they're at risk of imminent harm. And in order to get a restraining order, and then under this legislation, to dispossess a person of their firearm, and that it's granted roughly half the time. But I want to revisit this due process issue. So this notice or this notion of having the opportunity to be heard, I'm hearing is a defect in this proposal. Correct?
It's yes.
Yeah.
It's a big defect. Sure.
So puzzles me though is what's being offered as an alternative is the risk warrant statute, which I think has been on the books. Representative O'Neill, how long has it been on the books for, the risk warrant? 15 years?
Since 1999.
So for 15 years we've had a statute that, as far as I know, has not been ruled unconstitutional. But it seems to me that that process is a process by which you report a problem, and the police can go get a warrant from a judge. And the judge can issue a warrant, and as part of that process, someone can lose their firearms. That's my understanding. Is that your understanding?
Yes, and my understanding also is that the police sworn officers are presenting what's supposed to be credible evidence to that judge at that time. That's versus somebody that's another party that's in a dispute with somebody that may be having arguments over finances or over just household issues, or they're upset with them or they want them out of the house and they want to be able to get the upper hand, so to speak, and force that person out of the house and have their property seized, their firearms.
But it's my understanding, and I don't practice in the criminal courts, but it's my understanding that in a proceeding for a warrant from a judge, that is also an ex parte proceeding, and that a person doesn't have the opportunity to be heard when the police seek a warrant.
That's true, but the police are actually going to show up, and there's going to be at least interaction between the police and the party that's about to have their firearms seized. The police will actually be conducting somewhat of an investigation. And again, as I stated in my testimony, my off-the-cuff testimony, I'm sure that there's been abuse of this statute too, but we're not here trying to overturn that statute today. This is a statute that is on the books. We're trying to prevent another statute that's going to go even further above and beyond that, just because somebody says they feel threatened, as opposed to being able to substantiate any of the proof.
I do hope we're not trying to overturn that statute, because then
I don't think we'd stand a chance here today
we'd have nothing.
With the current landscape of firearms in the state of Connecticut and everything that's happened in the last couple of years. I don't think we'd have a shot at that. But
I guess
a guy can dream.
Yeah, I guess my concern is, I understand it's a different process. I understand probable cause is a standard in seeking a warrant, but in both instances, whether it's seeking a restraining order or seeking a warrant under the risk warrant statute, in both cases we have ex parte proceedings. In both cases, there isn't an opportunity to be heard, because there will be an opportunity to be heard at a later date within a reasonable period of time, but because the state is acting within its police power to keep people in this state safe.
Right.
And I think that's what we're talking about here today.
Right, but the minutia of the difference as far as how the procedure of how you go from somebody making a complaint to B, how it's done either through a police officer or through a judge is, in my opinion, worlds different.
Thank you. Further questions? Representative Dubitsky.
Thank you, Mr. Chairman. Thank you for staying. I know it's late, so I will try to be brief. I'd like to first ask you a little bit about House Bill 6962, the safe storage bill. I have read this bill a number of times, and it appears to me that under this bill, a person who owns a firearm would be prohibited from storing it in any way that any person other than themselves could get access to it. Is that how you interpret this?
Yes, that is Representative Dubitsky. I interpret it as that now the state of Connecticut, if this is enacted, is really sticking their nose further and further into people's private homes and private lives, because there's nothing prohibiting somebody that's not a convicted felon or abuser, or domestic violence, convicted of misdemeanor domestic violence, or federally prohibited otherwise via adjudicated mentally deficient, from being able to touch that firearm. So in essence, the state of Connecticut is saying you can't have that firearm to where somebody can actually gain access to it. And I know, I keep up with home invasion reports around the country, and there's a lot of people that use their parents' guns or use their spouses' guns to protect and defend themselves in the event of a home invasion.
Right, and
why would we want to limit somebody from the ability to do that?
Right, and the current language makes it prohibits people from storing firearms in a way that an ineligible person could gain access, and that language seems to have been removed and replaced with any person, essentially. So for example, if I were to store a firearm in my house, I would be required to store it under this, so my wife or somebody that I authorized to have access to that firearm could not reach it.
Yeah, that's the way we're interpreting the bill. Yes, absolutely.
Okay. And I assume that you're not happy with that.
No, absolutely not. I think that, you guys have a hard job, and you're always trying to hear arguments from every which way as far as why this should be done or why that should be done, and it's not easy. But at some point, you just cannot completely legislate safety. You can't stop the kids from coming into your swimming pool that live 3 houses down. Yeah, you can put up fences and try to slow them down or whatever, okay, but they're going to get in there. People are going to ski off of mountains, and they're going to hit the tree, or they're going to go off the cliff. This is not a perfect world that we live in, and there's not going to be a solution to every problem. At some point, really, human nature has to take over.
Let me go back to the which bill is it? The one with the bill we've been talking about all night regarding the temporary restraining orders. 650. Thank you. With regard to the temporary restraining orders, and I apologize, I'm getting a little tired. We've been at this for a long time.
Yes.
When we've been talking for a long time about getting the firearms back. Now, I imagine that there are a lot of people after charges have been found not to be justified, and we've heard testimony that it could take up to 2 years, even if the temporary restraining order is lifted. What effect, if any, do you think this bill would have on the current state of affairs with regard to any backlog or anything like that?
It's going to increase the backlog because now everybody that's subject to an ex parte restraining order, and if they happen to own firearms, they're going to be thrown into the hopper should they choose to try to have a hearing if anything is clear, if everything is cleared, and they want their firearms back and they want to be able to carry a firearm for self-protection, and we're here talking about protection. Keep in mind that for over 2 years, individuals won't have the opportunity or the ability to protect themselves, many wrongfully. So if you're going to tack on additional time, there's no in between measure right now. There's no intermediary step, as was I think mentioned a couple times today, such as I'll call it pistol permit purgatory, okay? And that is rather than a full revocation, people. And again, it's hard to support any of this because of the due process part. But when you guys go back to the sausage factory in the back room, maybe that you can think about measures such as putting in, instead of that full revocation, some type of temporary suspension of it until things are sorted out. So that way, the day after the restraining order expires and a person's given the clear ability to own their firearms again and possess them, then at that point they go, here you go, here's your pistol permit, go down and get your handguns, and also you have to throw in now, because now there's no measure to, as somebody pointed out earlier, to have a so-called assault weapon returned to you, because there are people in Connecticut right now that had their orders thrown out and they're not able to get their so-called AR-15s or so-called assault weapons back. So that should be looked at as well.
Okay. Well, obviously there's a grave difference of opinion as to whether or not taking the firearms in the first place or compelling them to be turned in the first place constitutes a lack of due process. Obviously, there are people in this room who believe that it is given due process, and you've testified that you don't think so. But getting past that particular point of time to the point where a hearing has taken place and it's been determined that the firearms when it's been determined that there is no justification for continuing to keep firearms from the recipient of the TRO, I think both sides have pretty much been on par that the person should get them back right away.
Yes.
So your suggestion perhaps is during the period of time that there's a temporary restraining order, maybe there would be a temporary suspension as opposed to actually a transfer or actual revocation?
Right. Well, I mean, my preference would be for due process, as I see it, and the people on the pro Second Amendment side of things seem to see it. I would prefer that be held up, but again, if that were to come out somehow, I think that it's more palatable to people. But again, on the face of it, I still see due process violation. And that's right now my main concern.
Okay. Thank you, Mr. Chairman.
Thank you. Further questions? Thank you again for your patience.
Thank you all very much. Thank you, guys.
Poe Murray.